This is Dr. Herskowitz again, and this is the second half of Chapter 7 talking about property. Just a quick recap quiz. If you're married and want to make sure that your home goes to your spouse at your death, how should you take title? In a life estate, tenants in common, joint tenants with a right of survivorship, or a sale leaseback? Let's see. That's either B or C. You look at it and make sure that you're correct on it. Okay, how do we transfer real estate? Well, the easiest way is by a sales contract. That's how we look at it all the time, buying and selling houses. Also, property is transferred by inheritance. It can be a gift. It's by possession, squatter's rights, eminent domain is another way where the government has the right to take property so long as it gives fair consideration for it. Or there can be a foreclosure by a lien holder, a lender. Contract, we're going to be talking a lot more about this in the next couple of weeks, but contract rules control the way that owners make agreements to exchange resources. That's basically what a contract is. And so it allows individuals to commit to future legal actions, exchanges of resources. It allows a person to sue another if an agreement is breached, or if they buy something that wasn't what they thought they were buying, or what they were told they were buying, actually. Statute of frauds is very important in real estate transfers because all real estate transactions must be in writing. We'll discuss this again under contracts, but just remember that statute of frauds requires that any real estate transactions be done in writing. You can acquire resources through a gift. The donor gives something. The key on that is that there's the intent to make the gift. It's actually delivered by physical transfer to the donee and accepted. And in the concept of contracts, it's very important because no consideration is paid. A gift is just what it says. Something is given to somebody else for other than monetary reasons. Testamentary gift is a gift through a will. Also, you can acquire land through a possession. First person to own it. Anything that's been abandoned, the first person to repossess it is the owner of it. That's why you have people looking for wrecks and abandoned ships. The first person that gets back to a ship now owns that ship. And the book talks about lost items as well. One thing I want you to look at is adverse possession. This allows a person to obtain real estate when the possession is in the exclusive possession of the person. It's open, visible, and notorious, which you cannot adversely possess a piece of property by not letting the other person know that you're there. Notorious just means that it is open and visible, and it is exclusive to the person claiming it. It has to be continuous possession for a required period. It's different in each state, but it's between generally 5 and 20 years. It has to be hostile and adverse. This doesn't mean you have to be fighting over it. In fact, if the person comes back and claims the property, that would stop the adverse possession. Hostile means that the person claiming it is the one that exclusively possesses it and keeps the other, the actual owner, out. And it has to be adverse, where the person is claiming it for themselves, and it's not with the approval of the owner. Adverse possession historically is how a lot of the land was possessed and came into ownership as people were moving west in the U.S. Okay, that's how you can get property, but the actual ownership of the property is evidenced through a title. This is a written document that conveys the title to real estate. And a certificate of title is a written instrument to convey title to personal property. So you'll have a certificate of title for a car, and you'll have a deed for real estate. Different types of deeds. a quitclaim deed. It's the weakest form of the deed. It actually says that I don't know if I own this, but whatever I do own, I'm transferring to you, to the grantee. This is basically used nowadays to clear up titles. So somebody may have a claim. You may be concerned that they may have some kind of a claim from years ago or something like that. Well, rather than going through all the records, and then they certainly can't give you a warranty deed, which we'll talk about in a minute, if they don't own the property. So they give you a quitclaim deed, and they say, anything that I own, I give to you. They don't claim to own anything, but if they do have any rights, leasehold rights, subsurface rights, anything like that, they can quitclaim it to the other party. A general warranty deed is the most common type of deed. The grantor, the seller, warrants to the grantee, the buyer, that the title to the property is valid and that they own it. There's no liens or encumbrances on the property except those noted in the transfer, in the deed. And title insurance guarantees the warranty deed these days. Then there's another kind called a deed of trust. It's not really a deed transferring ownership, but a deed securing a debt. And the transfer of ownership to a trustee, which occurs only if the loan is in default. So deed of trust does not transfer ownership, but it secures a debt. Recording deeds, this has been used since colonial times. It's very, very important. Recording is not required to transfer property. If you buy a house, you do not have to record that deed to own it. Once the deed is signed, you are the one that is the owner of it. Well, what happens if the seller turns around and then sells it to somebody else and gives them a deed as well? So now you have two deeds. Which one takes priority? Well, it's a public notice, and it's first in time is first in right. So recording of deeds guarantees that you get the right that you thought you did. Two competing claims, both with proper deeds. The first one recorded is given title to the property. And this has become the only way that property rights are transferred these days. Everything is done by recording, and title companies, insurance companies, banks, lenders all look at the recorded information to see what the claims are against that property. Recorded, the deed is submitted to a county recorder. They put a date timestamp on it, and anything after that is subject to the recorded document. It becomes a public record in the chain of ownership. Make sure you spend some time looking at this in the book so that you understand the importance of recording deeds. Different types of security interests. You have mortgages and deeds of trust. They both guarantee debt. It's slightly different ways of doing it. Look at that in the books. Make sure you understand the difference between a mortgage and a deed of trust. Security interests are property applications. This is why the value, the growth of the U.S. has come basically because of the security interests that people can have in their property. Mortgages on homes and lands. Banks make the loan. The individual can use it to buy the house. If there's equity in the house, they can get a loan. They can borrow that money to start a business, to do whatever they want. So it is a very, very powerful segment of that engine of prosperity and that engine of business throughout the U.S. Deeds of trust, borrower signs a note and a deed of trust, and that becomes security. If the borrower defaults, the trustee will actually foreclose on the property, give the property to the bank, and give any excess proceeds on a foreclosure sale back to the borrower. Recording statutes. Hernando de Soto, The Mystery of Capital, talked about how you can release trillions of dollars of capital through proper security and recording statutes, so that lenders have assurance that they're going to get paid. That means that a person can use the security, the value in their home for more than just living in it. They can use that, they can borrow on it, they can use that to start businesses, all sorts of things. Fascinating book. If you ever get a chance to read it, I strongly encourage you to. Foreclosure is when a creditor goes through a court system to ensure that all the proper procedures are followed, and then that is when a loan is not paid, it's in default. The lender goes through foreclosure. A deficiency is if the amount bid at the foreclosure sale is not enough to pay off the loan. The bank can still come after the individual for a deficiency. Some states make getting that deficiency very, very difficult. In California, there's basically no deficiency if the bank elects to do a power of sale foreclosure rather than a judicial one. Power of sale takes about 60 or 90 days. A judicial foreclosure can take 2 to 3 years. So most of the lenders in California will waive any deficiency to be able to get control of the property. Right of redemption is just a statutory right that a borrower can redeem their property within a period of time. It's usually 60, 90 days, not very long, if they pay off the loan. Okay, covenants and deed restrictions, CC&Rs, they run with the land. Make sure you understand that. An easement is the right to use someone else's property. Easement appurtenant is the appurtenant land. So here you would have the neighbor's property, the appurtenant, and the owned property, the property that you own, and there's an easement from the road to the property B. This easement gives the owner the right to go over your property. It's not exclusive. You can use that road as well. And so you have easements appurtenant. Easements in gross, this would be like a power line or a utility, where it's an easement that goes across a lot of properties for the benefit of the community, not for one single property. You can have an express easement. It's transferred by title. You can have an implied easement, easement of necessity. If a piece of property is landlocked, they have to have some way to be able to get on and off. And then an easement by prescription, that's squatters' rights, and that's basically the same way as we were talking about on adverse possession. So make sure you understand the different types of easements. Look at this quiz. The best way to buy your home is a warranty deed, of course. You have zoning ordinances. These are restrictions on the property that a party must adhere to, and it's given by the government. Okay.